Ken Klukowski of Breitbart News joins us on the program right now. Ken, how you doing, sir?
Doing great, Cam. Congratulations on the pork.
Thank you very much. Next time you come into the studio, we'll cook up some bacon.
Sounds like a plan.
All right, and maybe we can celebrate. Because we couldn't do it yesterday. Supreme Court deciding not to consider two cases brought by the NRA. What's your take on this, Ken? I mean, again, it takes 4 justices to agree to take a case. A lot of court watchers had anticipated that the court at some point will take another case dealing with the Second Amendment, and a lot of court watchers thought that these cases brought by the NRA presented excellent cases for the court.
Yeah, and I was one of them. I guess a couple points to make, a couple disappointing and then one upbeat. First of all, it is disappointing that they did not take these cases. They were good vehicles. They were raising points that are vitally important for the Second Amendment. See, Cam, people need to remember, it is critically important, and this has implications for the 2014 midterms and the 2016 presidential race. The Second Amendment to the United States Constitution only survived by a single vote twice at the U.S. Supreme Court. You had 4 out of 9 justices who ruled twice to say that the Second Amendment does not apply to private citizens at all. Put simply, you and I do not have a constitutional right, says these 4 justices, to have any guns whatsoever. The government can completely ban them. This is, while the Second Amendment's been in the Constitution since 1791, and 90 million Americans practice it every day, and almost 80% of Americans support it every day, it is still in the law a very, very new and fragile area now. We need more victories. We need to drive the stake in the ground, put down some deep roots, so that even if the court drifts to the left because President Obama gets another pick or someone like Hillary Clinton, goodness forbid, were to become president, that the Second Amendment could potentially be protected. So this is an extremely important time, and it's very, very disappointing that the court did not take this case. Now, in terms of why they didn't do it, there's one of 2 reasons, one of which we can try and plow through. The other one, if it's true, is a problem. The one we can all together try and plow through is that the number one reason why the Supreme Court takes a case is if you have what's called a circuit split. The country is split between 12 federal courts of appeals into 12 different circuits, as we call them, and typically the court will wait until 2 or more circuit courts go in opposite directions on an issue. Then they'll take it up and resolve it with the national standard. With the Peruta case out of the California-based Ninth Circuit that we talked about just a couple weeks ago. With the Peruta case, there is now a circuit split on whether the Second Amendment extends outside your home. It's a split with the Second Circuit out of New York. Now that that is the case, the Supreme Court may well take that case up, and if so, I believe we could be looking at a significant victory for the Second Amendment. If, on the flip side, there were not 4 justices to take this case, because once they started discussing it, a couple of the more moderate justices, perhaps like Justice Kennedy or Chief Justice Roberts maybe even, started saying things expressing some doubts about extending Second Amendment protections, then maybe some of the more conservative justices like Antonin Scalia would have gotten concerned about pressing forward. He'd rather have no precedent than a bad precedent, and that's why they didn't vote for it. We do not know which of those 2 are the case. We will not find out until they decide the next Second Amendment case. The court never leaks its secrets. We have no idea what was said behind closed doors, but I think it's one of those 2 scenarios. Either way, we need to get a case up soon.
All right, and to that end, Ken, we don't know what's going to happen with Peruta, but we do know the sheriff is not going to appeal this decision en banc. He's not or up to the Supreme Court. So that would leave it either the Attorney General Kamala Harris intervenes in the case, which she has so far declined to do, or a judge on the Ninth Circuit decides to ask for an en banc review, which is not it's not impossible, but that would be it would not be a normal circumstance, correct?
It would not be normal for a judge to try and press for en banc if no one was pressing for it. If I were the California AG, Frankly, if I were her, I would be trying I would petition for en banc. It's surprising that the local official in San Diego is not, because right now, if you live in one of the states of the Ninth Circuit, that's not just California, but that's all the way from Arizona to Hawaii to Alaska to Montana. It is a very large circuit. In fact, it should be split into 3 circuits if you look at actually what the historical standards are. But setting that aside, right now, the Ninth Circuit, which is the most liberal federal appeals court, has the single broadest and most conservative reading of the Second Amendment. And right now, that is the law of the land in all of those states. And it is a court that, because it is so left of center in its tilt, we just happen to get 2 solid conservatives on the 3-judge panel that heard this case. If they were to take it en banc, frankly, they would have a good chance of the left would have a good chance of winning en banc. Of course, then it ping-pongs back to us, and we try and take it to the U.S. Supreme Court. But still, right now, they are looking at a tremendous loss if you're in one of the states of the Ninth Circuit. And I would think that the California AG would try to take it en banc, confident that they could switch it in an anti-gun direction. And if you're them, just trying to roll the dice of hoping the Supreme Court doesn't take it for some reason.
Right. Well, I mean, that's the thing. You know, there's a lot of chess being played here.
Absolutely.
Ken, and if the Attorney General Kamala Harris decides not to get involved, as you say, that means in the Ninth Circuit, which would include California, which would include the state of Hawaii, that this this ruling will be the law, which means that you have to have some form of fashion that allows people to carry a firearm for self-defense outside of the home.
Exactly right. And if you're on the left, I mean, it is quite possible, Cam, that if the U.S. Supreme Court were to take up this issue, whether it's through Peruta or some other, the court is not a conservative court. This current court is a moderate. It tilts liberal on some issues. It tilts a little conservative on others. It's pretty much in the middle right now. There is a good chance that if they were to put their own Supreme Court level decision on this, that it would be significantly more narrow than what the Ninth Circuit handed down in its opinion by Judge Dermot O'Scanlan. So, I mean, if you're anti-gun, you have to figure that, first of all, we might be able to make this go entirely anti-gun, but even if it does end up at the Supreme Court, the Supreme Court's decision could be a whole lot worse from an anti-gun perspective. It could be a whole lot better, a whole lot worse for gun rights, a whole lot better for gun control than what's currently on the books. So for the life of me, I can't see why they would want to let this current opinion, written by a very solid Reagan constitutional conservative judge, why they would want to live under that as the supreme law of the land.
Yeah, well, I guess we'll see what happens. How long does Kamala Harris have, and how long does do the judges on the Ninth Circuit have to decide whether or not they're going to try to raise this appeal?
Oh, excellent question. That's actually determined by circuit rules, and I am licensed in the Ninth Circuit. I'm licensed in a number of federal appeals circuits. I confess I don't have that in front of me. For most courts, it's typically 2 or 3 weeks that the losing side has to petition for en banc, and then the losing side also has, either after the panel decision comes down or after the en banc decision, or after you petition for en banc, but that gets denied. Whichever of those 3 things happens last, then you have 90 days to petition the U.S. Supreme Court to take the case if you lost in the lower court.
All right. Well, listen, Ken, thank you very much, sir, for coming on the program. It's good talking to you, and hope we can do it again very soon.
Thanks, Cam.
You bet. Ken Klukowski joins us from Breitbart News.